Everything you need to know about New Jersey probate. Navigating the probate process in New Jersey can feel overwhelming, especially during an already emotional time. Whether you're planning for your estate or managing a loved one's affairs, understanding probate is crucial. In New Jersey, probate involves validating a will and distributing the deceased's assets. These legal steps ensure that the estate is managed according to the deceased's wishes, offering clarity and protection for beneficiaries. The legalities of New Jersey probate. Probate in New Jersey is a structured process, governed by specific legal requirements. After a person's death, probate usually begins no sooner than 11 days later. The executor of the will files the necessary paperwork with the surrogate's court in the county where the deceased resided. This includes a certified death certificate and the original will. If the deceased did not have a will or failed to name an executor, the court appoints an administrator to oversee the process. During probate, the will must be validated, assets appraised, and debts settled, all under the careful management of the executor or administrator. In some cases, probate may be denied if the will wasn't properly executed, and the matter can escalate to the state Supreme Court. Moreover, New Jersey's laws ensure that probate proceedings cannot commence until at least 11 days after the death, giving executors time to gather documents and prepare. It's important to note that in some circumstances, probate may not be necessary, particularly if assets are jointly owned or set to transfer directly to a beneficiary through life insurance policies or retirement accounts. This legal process ensures that assets are distributed fairly and according to the decedent's intentions. When does a will need to go through probate in New Jersey? Not all wills in New Jersey must undergo probate. If the decedent's assets were held jointly, they typically pass to the surviving owner without requiring probate. Life insurance policies, retirement accounts, and other assets designated to a specific beneficiary can also bypass probate. However, if assets are solely in the decedent's name, probate becomes necessary to transfer ownership to the beneficiaries. Without this legal step, there is no formal way to distribute these assets according to the deceased's will. The process is initiated by the executor, who submits the original will and the death certificate to the surrogate's court. Even when probate is necessary, some small estates can avoid it. If the estate is valued at less than $10,000 and a spouse is the sole beneficiary, probate can be avoided by filing an appeal. Without a will, the spouse may still bypass probate for assets under $20,000. In cases where there is no will, no spouse, and the estate is valued under $5,000, the next of kin can also file an appeal to skip probate. What is the probate process in New Jersey? Probate officially starts with the filing of paperwork, including the death certificate and a will, at the surrogate's court. If there's no will or an executor was not named, the court assigns an administrator. The executor or administrator is responsible for notifying creditors and family members about the probate through a formal notice of probate. After the court validates the will, the executor must manage and appraise the decedent's assets, handle any outstanding debts or taxes, and eventually distribute the remaining assets to the beneficiaries as stated in the will. One unique aspect of probate in New Jersey involves protections under Matus Law. If a beneficiary has a developmental disability, the executor is required to post a bond unless there's an exemption. This ensures that the interests of vulnerable beneficiaries are safeguarded. In some cases, probate may extend over several months, or even a year, depending on the complexity of the estate and legal challenges. Once the court is satisfied that all debts and taxes are settled, the remaining assets are distributed to the heirs as directed by the will, and the estate is closed. Your path to a successful probate experience. Understanding probate is key to ensuring that your loved one's estate is handled properly. In New Jersey, probate is sometimes necessary to settle a person's estate. It involves a series of steps, including the validation of a will, settling debts, and distributing assets. While not every will requires probate, it is a crucial process for estates where assets are not jointly held or assigned to specific beneficiaries. The Matus Law Group, located at 81 East Water Street, No. 2C, Toms River, New Jersey, 08753, is here to guide you through this process. Whether you're preparing your estate or dealing with a loved one's, it's essential to have experienced legal support. Contact our law firm at 732-281-0060 to schedule a consultation and get the assistance you need for navigating New Jersey's probate process.